I'm Brittany James, and I help consumers understand, protect, and enforce their financial and credit rights. If there's any error on yours, we will fix it. For more info, click the link in our bio or comment section below to speak to one of our licensed attorneys for help. What if I told you that filing for bankruptcy the wrong way can actually make your financial situation worse than before you filed? Most people think bankruptcy is a simple escape hatch. File the paperwork, wipe the slate, start over, done. But here's the truth: nobody in the financial industry is rushing to tell you. There are 5 specific mistakes that get bankruptcy cases thrown out every single day, and most people walk right into them without even knowing it. Stick with me for the next few minutes, because whether you're filing tomorrow or just exploring your options, this information could save you thousands of dollars and years of financial pain. Hey, welcome back. If you're here, you're probably dealing with some serious financial pressure: debt collectors, overdue bills, sleepless nights. First, I want you to know, you're not alone, and there is a path forward. Bankruptcy law exists for a reason. It's a legal tool designed to give real people a real second chance. But like any powerful tool, using it incorrectly can do more damage than good. Today, I'm breaking down the 5 biggest pre-bankruptcy mistakes that derail cases before they even get started, and exactly what you should do instead. Let's get into it. Mistake number 1: unfiled tax returns. Let's start with the one that surprises people the most. If you have unfiled tax returns, meaning you were legally required to file but didn't, you cannot successfully move through the bankruptcy process. Period. Here's why. Bankruptcy trustees are legally required to review your tax returns as part of verifying your financial picture. If those returns don't exist, the trustee has no way to confirm your income, your assets, or your overall financial situation. And they don't just shrug and move on, they move to dismiss your case. This applies to both Chapter 7 and Chapter 13 filings. It doesn't matter which route you're taking, unfiled returns are a wall you will hit. Now, I know what some of you are thinking. My taxes are complicated. It's expensive. It's overwhelming. I hear that. But here's the thing: many situations are simpler than they feel. If you worked a regular job and had standard income, there are straightforward filing options that won't cost you a fortune. The action step. Before you do anything else, figure out which years you're behind on. Then get them filed. It's not optional, it's foundational. Mistake number 2: joint bank accounts. This one shows up constantly, and it almost always involves family. Here's the classic scenario. Years ago, you added yourself to your teenager's bank account so you could transfer them money when they needed it. Smart parenting move at the time. But now they're an adult, you're considering bankruptcy, and that joint account? It's a problem. When you file for bankruptcy, you are legally required to disclose every account you have ownership in, even if you never touch it, even if your money isn't in it. If your name is on your adult child's account, their deposits, their balance, their entire financial activity on that account becomes something the bankruptcy trustee can start asking questions about. It doesn't necessarily blow up your case, but it creates unnecessary scrutiny, delays, and paperwork that you could have avoided entirely by simply removing your name from the account. The action step. If your name is on anyone else's bank account, child, sibling, parent, anyone, talk to a bankruptcy attorney immediately about whether and when to remove yourself. Timing matters. We're halfway through, and what I'm about to share in mistakes 3, 4, and 5, these are the ones that don't just delay cases, they can cost people their property, their family relationships, and potentially expose them to serious legal scrutiny. Keep watching. And if you're finding this valuable, do me a favor right now. Share this with someone who needs to hear it. You might save them from a decision they can't undo. Mistake number 3. Non-exempt assets you don't know about. Here's where bankruptcy gets more nuanced than most people expect. Bankruptcy law doesn't just wipe debt and call it a day. In a Chapter 7 case, a trustee is actively looking for assets that can be liquidated to pay your creditors. Now, most states protect certain assets through what are called exemptions, legal shields that say, this cannot be taken. But here's the danger: people often don't know what's protected and what isn't. For example, many states protect a specific dollar amount of equity in your primary vehicle. If your car is worth more than that protected amount and it's fully paid off, the trustee can seize it, sell it, give you back the exempt portion, and distribute the rest to your creditors. The same logic applies to boats, motorcycles, motorhomes, trailers. Anything of significant value that isn't covered by an exemption is potentially fair game. The action step. Before filing, get a realistic, honest picture of everything you own and what it's worth. Then, work with a qualified attorney to map those assets against your state's exemption laws. This isn't just paperwork. It's the difference between keeping your stuff and watching it get auctioned off. Mistake number 4. Transferring assets before filing. This is the one that trips up people with the best intentions. You're thinking about bankruptcy. You've got a boat, a motorcycle, a piece of property, something you don't want to lose. So you think, what if I just transfer it to my cousin? Put it in my brother's name? Give it to my daughter? Do not do this. Bankruptcy law has what's called a look-back period. For transfers to family members, close friends, or business associates, what the law calls insiders, courts can look back 2 full years before your filing date. If they find that you transferred an asset during that window without receiving fair market value in return, they can legally unwind that transfer. They'll go get the property back, sell it, and distribute the proceeds to your creditors anyway. So not only did you not protect the asset, you potentially created legal complications for the family member you were trying to help. The only exception, if you sold something at a genuinely fair market price, documented properly, that's a different situation. But even then, talk to an attorney first. The action step, status quo. Don't move anything, don't transfer anything, don't give anything away until you've spoken with a licensed bankruptcy attorney who can guide the process correctly. Mistake number 5. Paying back certain creditors right before filing. Last one, and this one is deeply human, which is exactly why it keeps happening. When people are heading toward bankruptcy, they often want to protect the people they care about. If a family member lent them money, they want to pay that person back before everything gets complicated. It feels like the right thing to do. But bankruptcy law calls this a preferential payment, and it can backfire badly. Here's how it works. If you pay back a family member, close friend, or business associate within 1 year of filing bankruptcy, the court can actually pursue that person and demand the money back. They'll argue that your repayment gave that creditor more than they would have received through the normal bankruptcy process, which isn't allowed. For regular creditors, credit card companies, medical debt, etc., the look-back window is shorter, 90 days. But it still applies. Paying off one credit card right before filing doesn't help your credit score, doesn't remove it from the bankruptcy, and can create clawback complications. The action step. In the months leading up to filing, don't make any large or unusual payments to anyone, especially family. Every dollar movement should be discussed with your attorney first. So let's recap the 5 landmines. 1. File your tax returns, all of them. 2. Clean up joint bank accounts before filing. 3. Know your exempt versus non-exempt assets. 4. Don't transfer property to avoid losing it. 5. Don't make preferential payments to insiders or creditors. Here's the bottom line. Bankruptcy is a legitimate legal tool that genuinely helps millions of people reset and rebuild. But it rewards preparation and punishes shortcuts. If you're even thinking about filing, start by talking to a qualified bankruptcy attorney in your state, not a debt settlement company, not a credit counselor, an actual licensed attorney who handles bankruptcy cases. Many offer free consultations, and one conversation could save you from a mistake that takes years to recover from. Drop your questions in the comments below. I read them, and your question might become the next video. And if this helped you, share it, because somewhere in your circle, someone needs to see this before it's too late. See you in the next one. I'm Brittany James, and I help consumers understand, protect, and enforce their financial and credit rights. If there's any error on yours, we will fix it. For more info, click the link in our bio or comment section below to speak to one of our licensed attorneys for help.